नमस्कार, द रेड माइक में आपका स्वागत है। मैं हूं संकेत उपाध्याय। कानून की पाठशाला बहुत जरूरी है क्योंकि कानून बदलने वाले हैं और जब कानून बदलेंगे तो उसका जानना आपके और हमारे लिए बहुत जरूरी है। अब हम तो कानूनविद हैं नहीं, लेकिन जो कानून के मामलों के विशेषज्ञ हैं, उन्होंने एक चौपाल लगाई और उन्होंने चर्चा की इन नए कानूनों की, यानी कि भारतीय न्याय संहिता और भारतीय दंड संहिता, जो कि सीआरपीसी और आईपीसी को बदलेंगे और एविडेंस एक्ट को जो बदला जाएगा। इन तीन कानून के बदले जाने से और उनके प्रभावी रूप से आ जाने से क्या क्या चीजें बदलेंगी, उसके कई पहलू हैं और उन पहलुओं पर चर्चा की कपिल सिब्बल साहब, जाने माने वकील हैं, और उनके साथ थे एक और जाने माने वकील डॉक्टर अभिषेक मनु सिंघवी और मुकुल रोहतगी जी। ये तीनों, आप ये समझिए कि सुप्रीम कोर्ट में कोई भी बड़ा मामला होता है तो ये अपना केस आर्ग्यू करते हैं। हाल फिलहाल में आपने देखा होगा कि चाहे इलेक्टोरल बॉन्ड का मामला हो, चाहे चंडीगढ़ मेयर वाला मामला हो, यही तीनों वकील आपको इन मामलों को आर्ग्यू करते हुए दिख रहे थे। तो जब ये नए कानूनों पर चर्चा करते हैं तो इसको गंभीरता से लेना बहुत जरूरी हो जाता है। अब ये अलग अलग पहलुओं पर बात कर रहे हैं, तो आइए सबसे पहले एक महत्वपूर्ण प्रावधान इस कानून में ये है पीएमएलए के जो सेक्शंस हैं, और ये सिर्फ इसी कानून में नहीं, अभी भी कानून बदल गया है और पीएमएलए के तहत बेल मिलना अब थोड़ा सा मुश्किल है, थोड़ा क्या काफी मुश्किल। इसको लेकर के ये तीन कानूनविद क्या मानते हैं, क्या सोचते हैं, आइए सबसे पहले आपको ये चर्चा सुनाते हैं।
Question before I go to Dr.
Yes.
Singhvi. See, our law says that I can arrest, a police officer can arrest a person on suspicion. Now, suspicion is a subjective thing. So you have drastic laws like UAPA, you have drastic laws like PMLA, and you can arrest a person on suspicion and nobody can challenge it. This very process of arresting somebody on suspicion without fully investigating the matter
So again,
is a very dangerous thing.
yes, so I come back to this. If you look at those laws in the light of the constitutional freedoms, you need to tweak those laws. You tweak it in the light of the Constitution, that you don't give the power of arrest to a junior police officer who will lock you up. And tomorrow, if it is found that there are no real grounds, in our courts, there is no compensation for vexatious arrests. They, well, I thought he was guilty, I have arrested, that's the end of the matter. So you must tune it in that, and even if you have some drastic powers because of terrorism and stuff like that, give it not merely to a senior police officer. That by itself hasn't worked. You know, you have,
Yes,
it
absolutely.
hasn't worked.
Yeah.
So you must have some checks that it must go through 2 or 3 levels of senior officers who should on the file order that yes, not 1 but 2 or 3 have seen the basic facts and we feel that an arrest is made out. Unless it's a case of somebody committing a crime in your
That's different. That's
in
different.
before
Yeah.
your eyes, like somebody committing a murder.
Right.
But if you have these things and you have those checks, again you look at the touchstone of the Constitution, maybe we can.
तो आपने सुना, ये थे मुकुल रोहतगी। सरकार के पक्ष से कई बार आपने इनको आर्ग्यू करते हुए सुना है और इनका ये कहना है कि नहीं भाई, चेक और बैलेंस होना चाहिए, हर किसी के पास ये हक नहीं होना चाहिए कि आप गिरफ्तार कर लें, क्योंकि फिर तो हर कोई गिरफ्तार कर लेगा और बाद में फिर क्योंकि कोई दंड का प्रावधान नहीं है गलत गिरफ्तारी करने के लिए, तो ये गलत बात है। उनका ये कहना है कि ये कई चेक और बैलेंस के साथ आप इस तरीके से अरेस्ट कर सकते हैं। अब बेल, पीएमएलए खास तौर से जो मामला है उसमें बेल के प्रावधान पर डॉक्टर अभिषेक मनु सिंघवी क्या बोलते हैं, आइए आपको वो सुना दो।
Now, bail in the most serious offenses everywhere in the world, you get bail. Leave aside a few categories of terrorism or child molestation, etc. You get bail. The classic and the only test for bail is that A, you have a presumption of innocence, and the presumption of innocence can be only effectuated by giving you bail, but putting you on conditions. And it is what we call the famous triple test. You will not interfere with witnesses, you will cooperate, you will not flee, and there is no flight risk. But that is actually in practice, and I'm now talking of the judiciary, turned on its head by adding a fourth test, which has no place according to me if you marry the principle of presumption of innocence and freedom. That is कि हाँ भाई, इनको फ्लाइट रिस्क भी नहीं है, ये कोऑपरेट भी करेंगे, ये पेश भी होंगे, लेकिन gravity of the offence. I have for long believed that I must argue a matter where this gravity of the offence must be investigated. What is the question of gravity of offence? You're not convicting me. You're not trying me. You are giving some subjective view of a gravity of the offence. The whole point of bail is that till you convict or acquit me on the gravity of the offence, you give me bail. So the point I'm making is assume all the three tests are in my favor. I have roots, I can't flee, I'm going to come every day to the police station. Still, bail is denied regularly on gravity.
It's the norm.
So this is turning the jurisprudence of bail on its head. Second example, this fact of creating more and more laws with skewed and special provisions for bail. I mean, Section 45 and all this of the PMLA or the UAPA is only some example. Point is, these provisions, and this is where I fault the judiciary, have to be consistently interpreted by the apex court to give us clear direction and momentum. What happens is today, this judge interprets it in the right way. But then there is some inconsistency. I speak in a different voice. So there is chaos. These provisions have to be interpreted very strictly. Many of them actually have to be interpreted on the constitutional anvil. And I would say the best example is Nikesh Tarachand Shah very, very minutely examined the constitutional validity of that 45 provision of the PMLA, which is draconian, and said it's not constitutional in many ways, but yet our own courts have then held it differently. The point is, if you lean in favor of freedom, then, and otherwise you can't do it, then you have to have legislative intervention. That I don't think will happen easily.
तो ये आपने सुना, ये थे डॉक्टर अभिषेक मनु सिंह भी। इनका ये कहना है कि ग्रेविटी ऑफ द ऑफेंस पीएमएलए एक्ट में जो ये प्रावधान बदला, उसकी वजह से क्या हुआ कि एक आपने एक कंडीशन क्रिएट की जिसमें बेल नहीं मिल सकती, और वो अपने आप में एक चिंता का विषय है, और वो इसके खिलाफ आर्ग्यू कर रहे हैं। हालांकि सरकार, आप जानते हैं, उन्होंने ये प्रावधान लागू कर दिए हैं, और ईडी के जो पीएमएलए मामलों में जो गिरफ्तारियां होती हैं वो इसी के चलते होती हैं, जिस वजह से बहुत सारे लोगों को बेल नहीं मिलती है। अब यही चर्चा आगे और बढ़ाई इन तीनों वकीलों ने, तो आइए फिर से सुनते हैं कि ये क्या कहते हैं।
Take the conversation back to prior to bail, the custody by the police.
Right.
I think bail comes later,
Yes.
custody comes first. So what are the parameters for custody is the question I started with. You went on to bail, but we'll deal with that a little later.
Yeah.
So what are thoughts on that?
It's very important. We have stopped for many decades making a distinction, Kapil, between power of arrest and need for arrest. This is a fundamental fallacy. I have a power of arrest. I equate it to the need for arrest. Today, according to me, forget the fact that you are filling up your jails with unnecessary occupants. Forget the fact that you are doing it politically motivated in many cases. Forget the way that you are harassing. The fact of the matter is that I would say more than 90% of arrests would not be justified if you made the difference between the need for arrest and the power of arrest.
Correct.
All
So
the
what
arrests,
do you need to do to justify that need for arrest is the question.
see, there are two things.
Yeah.
Ideally, there should be a filter required by legislation. You can say you will first record these, it will then go that stage. When two people have recorded, then you can arrest.
what
That
I'm
is one.
saying, yeah.
But that's never going to happen. Unfortunately, it is not easily going to happen. Whoever is in power, you tend to go with the power. It is for the courts to start reading it like that. And but again, there, consistently 5 Supreme Court judgments the same line, then the law will be laid down. You have to say that, what is the point of arrest? You are arresting people, Kapil, in most cases we are all doing, after 2 years, after 3 years. Anything you wanted to collect is there, papers have been collected, raids have been done, statements have been recorded. What is the need
But
for
you
arrest?
are also arresting people without any evidence at all.
That's the other
That's
category.
It's a far more serious issue, because now if you target individuals who you're politically against and you arrest them without any evidence, and then no bail is granted because there is a suspicion that they have committed the crime, where do we go from there? And if you add 120B, which is what is conspiracy, you know,
That is
he's not
ridiculous.
directly involved in any offense, you will say 120B, conspiracy. Now you can't prove conspiracy. There is no basis for proving conspiracy, but you'll keep him behind bars. So the issue is, how do you formulate a legal framework within which an arrest must take place? The hierarchy of officers is not going to make a difference, and I agree with you. We need a framework through which arrest can only happen if prima facie it is established that I have committed the offense. Unless you're able to show that to the magistrate, there should be no arrest.
ये थे कपिल सिब्बल और अभिषेक मनु सिंघवी, और जिसमें हम देख रहे थे कि मुकुल रोहतगी भी बहुत हद तक इससे तैयार थे। यहां बात है बेल की, बात तो तब आएगी ना जब कस्टडी यानी कि गिरफ्तारी हो। तो गिरफ्तारी के भी क्या प्रावधान हो, खासतौर से मनी लॉन्ड्रिंग के मामले में। तो अभिषेक मनु सिंघवी का ये कहना है कि आपको एक भेद जानना जरूरी है पावर ऑफ अरेस्ट में, यानी कि एक संस्था के पास ये ताकत है कि वो गिरफ्तार कर ले, और नीड ऑफ अरेस्ट यानी कि किस कंडीशन पर वो अपनी पावर का इस्तेमाल करे। तो वो नीड ऑफ अरेस्ट कि अब हमें अरेस्ट करना है और अब हम अपनी ताकत का इस्तेमाल कर रहे हैं, उसके नियम क्या हो। ये ना हो कि जिसका जब मन आए तब उठा करके गिरफ्तार कर ले, और यहीं पर राजनीतिक मिसयूज की बात आती है। तो उस पर यह बात हो रही थी कि एक कानून द्वारा एक फिल्टर होना चाहिए, जिसमें चिंता यह है कि जो भी सरकार आएगी वो ऐसा करना नहीं चाहेगी, क्योंकि वो भी चाहेगी कि लोग उनसे दब के रहें। और उनका यह कहना है कि समाधान यहां यह है कि कोर्ट्स यानी कि अदालत इसको इस तरीके से पढ़ना शुरू कर दें, और 5 जज, सुप्रीम कोर्ट जज की जो बेंच है, वो अगर ऐसे मामलों में इसको इस तरीके से देखना शुरू कर दें कि आपकी जरूरत क्या थी अरेस्ट की, पावर आपके पास हो या ना हो, क्या जरूरत थी, तो इस तरीके से कानून अपने आप बन जाएगा और वो परिभाषित हो जाएगा। ये मेरे ख्याल से एक बहुत अहम बात डॉक्टर अभिषेक मनु सिंघवी बोल रहे थे। ये 3 सज्जन एक बार फिर से प्रिवेंशन ऑफ मनी लॉन्ड्री एक्ट यानी कि पीएमएलए में बेल के प्रोविजंस पर एक चर्चा जारी करते हैं। आइए सुनते हैं उस चर्चा को, क्योंकि ये बहुत महत्वपूर्ण है।
Look at your PMLA, talk of bail, and read the provision for viewers. You will not get bail unless the public prosecutor has been given an opportunity to oppose the application for such release. And when the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of the offense. Now you tell me, if the accused doesn't know what's against him. I am arrested on suspicion. I am produced before the magistrate. I have no material with me. How do I convince the magistrate that I am not guilty, or how does the magistrate come to the conclusion that I am guilty?
Kapil, on the bare text, this is an
It must
impossible
be
provision.
struck, should have been struck down.
No, it was struck
No, it
down.
was struck down.
The tragedy is,
but it should be struck down again.
no, but the whole story doesn't end there. On its text, this is an impossible standard to satisfy.
Yes.
It was rightly struck down in a very well-reasoned judgment by an
Justice
outstanding
Nariman,
jurist.
yes.
But the amendment is very interesting, by which they're supposed to have restored it. According to me, those 3 words added
I
do
know.
not at all restore it. What happens? After that, in the period after a judgment called Nikesh Tarachand Shah, for your viewers, which struck it down, and till the amendment came, or even after that, even after the amendment, most of the high courts took a robust view. They said this does not mean that I must find him not guilty by a certification now. It cannot mean that. Therefore, we'll take broadly the same view. Then along came the judgment of the Supreme Court, which we are now trying to review. And therefore, that judgment really put the seal on what a robust view the high courts were
See,
taking, despite all this.
My fundamental objection to all this is contrary to our basic freedoms. And why should the court tolerate such legislative measures which destroys the very fundamentals of of the rights given to us under the Constitution? Now, if you look at the PMLA now, and the viewers will understand, you have a 420 offense which is cheating under the penal code. Now, if it is put in the schedule of the PMLA, it is 420 again. Under ordinary law, you will entitled to bail. If it's under PMLA,
No bail.
you will have to show that you're not guilty of
45.
the offense. I mean, what kind of law is this? And why is the Supreme Court not looking at these laws? That's the next question I have. These kind of laws and these kind of prosecutions are irreversible unless you hear the matter immediately. This matter,
Absolutely.
PMLA, has been pending now for months.
तो ये थे कपिल सिब्बल, मुकुल रोहतगी और अभिषेक मनु सिंघवी, जो कि बात कर रहे थे बेल के प्रावधान पीएमएलए पर। और इस बीच एक बड़ी अहम चर्चा करते हुए इनका ये मानना था कि ये जो कानून बदले गए हैं पीएमएलए के संदर्भ में, ये आपके जो बेसिक प्रिंसिपल्स हैं आजादी के, फ्रीडम के, ये उसको वायलेट करते हैं, उसको चोट पहुंचाते हैं। क्योंकि जैसे कि तर्क दिया जा रहा था, तर्क ये है कि अगर आप पीएमएलए के प्रावधान में चोरी की धाराओं में पकड़े जाते हैं तो आपको बेल नहीं मिलेगी, साधारण 420 में पकड़े जाते हैं तो आपको बेल मिलेगी। यानी कि एक प्रशासन के पास, एक एजेंसी के पास ये हक है कि वो तय कर सके कि अगर वो आपको इस प्रावधान के तहत, पीएमएलए एक्ट के तहत, अगर चोरी, छोटी चोरी के लिए भी अगर आपके खिलाफ केस दर्ज करती है, तो आपको इस कानून के माध्यम से वो जेल में रख सकती है, बेल नहीं मिलेगी और ओनस ऑफ प्रूविंग योर इनोसेंस वो आपके ऊपर होगा। इसके बारे में वो बात कर रहे थे। अब इस कॉन्वर्सेशन में, इस बातचीत में, बात पीएमएलए और बेल की होते होते एकदम से इलेक्टोरल बॉन्ड की ओर भी चली गई और ये बहुत ही रोचक बातचीत है जो कि इन तीनों के बीच में हुई। आइए आपको उसके बारे में बताते हैं, क्योंकि इन्होंने इलेक्टोरल बॉन्ड्स के बारे में भी बात किया, मिसयूज के बारे में भी बात किया। ये सारी चीजें अब आपको इस बातचीत में हम सुना,
which are of seminal importance with the liberties of our people, right? Those cases are not being heard for years, right? There are other matters that are being heard in priority. The question is, who decides the priority? Should the priority not be decided in the context of the damage it is causing to people whose freedoms are being taken away? Now, that should get priority, no? That is not in the hands of the system, that's in the hands of judges themselves.
And the best example of what you are saying is your recent judgment of electoral bonds.
Yes.
What happens is that the system ultimately reaches the matter and possibly gives the right result as it gave with the electoral bonds. But the damage is done completely.
Exactly.
A former Chief Justice has repeatedly in my presence said that we'll hear it next week, next month. That next month, next week in 2019 became 2024.
So the problem is in the PMLA, for example, if after say 6 months, 1 year, some of these provisions are declared to be unconstitutional.
Then what happens?
Then what happens?
For example, all the benefit
You
of
see,
the electoral bond was
Abhishek,
gorged.
You mentioned electoral bonds. I would still like to add, yes, it is important. It is more important for political people. An individual who's looking for bail or
I agree.
his roti or makan, you don't bother about electoral bond.
Yes.
Both of you are politicians, so it's important. But from
I didn't say that.
no, anyway, that's my thought. But as a pure practitioner of the law, what is more important by far is affecting liberty of hundreds of people.
This is what my
undoubtedly.
belief is. Yes.
I mean, I would rather say this should be heard.
Yes.
I don't give a damn about electoral bonds, whether 5,000 to BJP or not. The general public is not concerned.
No. General, we'll leave that out.
All right.
That's controversial.
No, my point is different.
But freedoms are far more
Important than all
My
others.
point is a
all
little
others.
different, that the time taken to give the right verdict, the benefit of the wrong
Yes.
is already absorbed.
Yes.
That's the point.
That's
It doesn't
the point.
matter electoral
Yeah, I
bonds
agree
or
with
liberty.
you. But then
Whatever
you see,
damage
it's
has to be
happening
done is done.
everywhere. But then it's happening everywhere. A small individual, he gets acquitted after 8 years. He has served the sentence. He has served
That's
everything.
another sad part.
उसको देखो, उसका क्या हो रहा है?
I agree with that.
But
But
you
they
have
should
to
decide these larger issues of law which will affect not individual, but
Therefore,
the whole batch of
PMLA,
cases.
according to me,
PMLA.
is the prime case which should be heard at the earliest for these kind of provisions, and as to whether it has been rightly passed as a law or not, which hits at the root.
That's right. And it should be heard, according to me, by 5 judges so that it settles the law. 5 senior most judges should sit
According
and
to
settle
me,
the law.
Kapil, the judgment which was delivered, which is the bane of all these problems, by a 3-judge bench, that's the procedure was wrong by saying, I will decide on the validity, but I will not decide whether it was rightly borne under the money bill or
That's
not.
correct.
You cannot separate. If you find you have upheld the law, people are in jail. They can't get bail for 5 years,
Correct.
4 years. After 3 years, suppose it is held that it was wrongly passed by Parliament, it could not have been done.
Correct.
How will everything else be undone?
Absolutely.
You can't leave that challenge separately. That should have been the first decision.
Absolutely.
Rather than 3 straight away, 5 or 7 judges. Is this law born correctly?
But assuming you're right, this court can easily hear the matter
Yes.
on the issue of money bill.
Yes.
It has been pending for long. Why shouldn't it hear it? That should have priority, especially in the
Yes.
context of freedoms.
According to me, that should be heard first.
Yes.
And then you
Threshold
issue a review
question.
of the judgment.
These are very important things.
I think they realize it, but it's just not happening because the threshold question will affect so many sectors, not
And
only
it'll be
PMLA.
irreversible. After a while, it'll be irreversible.
तो इन तीनों सज्जनों ने एक जरूरी बात की कि सबसे पहले तो इलेक्टोरल बॉन्ड पर चर्चा चली गई और वो बहुत महत्वपूर्ण है। आपको मालूम है कि उसमें वकील कपिल सिब्बल ही थे। तो अभिषेक मनु सिंघवी का ये कहना है कि आपने कोर्ट ने असंवैधानिक तो घोषित कर दिया, लेकिन 2019 से चला हुआ मामला 2024 में उसमें जजमेंट आया और 5 साल में एक असंवैधानिक सिस्टम के हिसाब से जिसको जितना लाभ मिलना था वो लाभ तो वो ले गए। तो इसमें डिले करना और समय लगना और समयबद्ध तरीके से इसका ना होना, क्या ये अपने आप में किसी को लाभान्वित कर रहा है? भले ही वो अनकॉन्स्टिट्यूशनल डिक्लेयर हो गया हो, असंवैधानिक डिक्लेयर कर दिया गया हो। इसके अलावा पीएमएलए पर ये लोग वापस आए और प्रिवेंशन ऑफ मनी लॉन्ड्रिंग एक्ट पर, जो मुझे समझ में आ रहा है इन तीनों वकीलों का ये मानना है कि अब एक जजमेंट आ जानी चाहिए 5 जजों की, जिसमें ये परिभाषित हो जाए कि ये सही है या नहीं सही है। और एक बात ये भी कही गई कि अब अगर कानून बदलता है तो उन लोगों का क्या जो कि इस बदले हुए कानून के हिसाब से जेल में सजा काट रहे हैं। संभवतः क्योंकि पहले मेरी इन तीनों सज्जनों से बात हो चुकी है, खासतौर से डॉक्टर अभिषेक मनु सिंघवी और कपिल सिब्बल, इनका ये मानना है कि ये पूरी तरीके से राजनीतिक है। आइए अब बात करते हैं, और ये बहुत ही रोचक पार्ट था, डिस्कशन था, क्योंकि जब मैं सुन रहा था तो मुझे लगा कि, और हमें भी ये लगा कि ये तो सुप्रीम कोर्ट पर ही सवाल उठाए जा रहे हैं। लेकिन मुकुल रोहतगी कुछ महत्वपूर्ण बात कहते हैं सुप्रीम कोर्ट के बारे में। वो क्या कहते हैं, आइए आपको वो सुनाते हैं। ये रहा वो पोर्शन
Liberty
जिसमें वो
of
सुप्रीम
hundreds
कोर्ट
and
की बात कर रहे हैं।
thousands obviously should get a priority and they should be heard. And according to me, not only this case, but there are several other cases. I mean, let's put it this way: to every individual, his case is important.
Yes.
To every individual, you know, he has his case to be heard. We have, unfortunately, we are into a big clog. You know, there's a clog of cases. There's the courts are full of cases.
Mostly corporate matters relating to corporate disputes.
My feeling is that unless we drastically amend the system of hearing of cases in courts, this problem will remain. I mean, you may aggravate it or you may bring it
Now,
down.
what do you mean by amend the system? Let me sort of ask you
What
that
I mean
question.
is that the whole system is skewed.
What is
skewed.
that? I mean, what?
The-
Let's
the-
come to specifics.
Yes, yes. Let's start with the Supreme Court.
Yeah.
The Supreme Court was formed in 1950 to hear a particular class of cases involving the Constitution or very, very important questions of law, of liberty, of freedom of press, of things like that. The Supreme Court itself, after 20 or 30 years, I would say, or after 20 odd years, it forgot. The Supreme Court has forgotten why it was established. It has today become nothing and nothing more than a regular court of appeal. Every day we do hundreds of cases in the Supreme Court. They are mundane cases. They should never have gone even to the High Court, much less the Supreme Court. Every bail goes to the Supreme Court. Every injunction goes to the Supreme Court. Unless you set that house in order. So you first set the Supreme Court in order, but you must have, you must revisit. The court must revisit what it was meant to do and what it is doing. That will then percolate to the High Court. The High Court will say what it is supposed to.
एक जरूरी बात मुकुल रोहतगी ये कह गए कि सुप्रीम कोर्ट को ये पता होना चाहिए कि वो गठित ही क्यों हुआ, सुप्रीम कोर्ट आया ही क्यों। वो अपना तर्क देते हैं और उनका ये कहना है कि 20-30 साल में सुप्रीम कोर्ट ये भूल गया कि वो गठित क्यों हुआ था, और अब सुप्रीम कोर्ट के लिए बहुत जरूरी है कि वो जाने कि वो क्यों गठित हुआ था। हर मामला यहां नहीं पहुंच सकता, कायदे से नहीं पहुंचना चाहिए। लेकिन फिर ये अपने आप में एक बहस छिड़ जाती है कि क्या सुप्रीम कोर्ट बस कुछ खास लोगों के लिए या खास मामलों के लिए ही है और वो सब लोगों के लिए नहीं है। क्या वो देश की सुप्रीम कोर्ट नहीं है, और देश की सुप्रीम कोर्ट क्या आम आदमी के लिए नहीं है, क्योंकि जैसे मुकुल रोहतगी बोल रहे हैं हर आदमी के लिए उसका केस इंपॉर्टेंट है। तो एक बहुत बड़ी बहस है जो उन्होंने छेड़ दी है। अब देखते हैं कि ये बहस कहां तक जाएगी और इस बहस को लोग ठीक मानते हैं या नहीं, मुकुल रोहतगी की बात सही मानते हैं या नहीं। क्रिमिनल कंस्पिरेसी यानी कि आपने एक साजिश के तहत कोई क्राइम किया, उसको लेकर के और उसके प्रावधान को लेकर के भी ये तीन वकील बोले। आइए इनके विचार जानते हैं।
Issue I want to discuss
स्क्रीन
with
पर
you,
अब
we have had a fascinating discussion, is about conspiracy 120B. Now, in every offense where you do not have direct evidence against an individual, you add 120B. Now, that man will never get bail. There is no proof of conspiracy till the end of the trial. Now, what happens to that category of cases and those accused who are involved in the 120B? Should 120B be used in this fashion under a
See,
criminal
that's the point.
jurisprudence?
First of all, it has been around, but the misuse and the use in which it is done now was not being done earlier. That's the tragedy. Even with similar provisions, you are really misusing it now. Number two, in every case, I'm finding an argument which is completely used not to be raised earlier, that 120B is a standalone. 120B, the tail will wag the dog. It will stand alone. Now, there is fortunately, and these are the kind of things which are required, judgment which says that you cannot have a 120B alone under, for example, the PMLA. It's a very robust judgment. But even today, as of yesterday or day before, the argument is still continuing. It is justified. It is not, there are any number of cases I am doing where 120B as a standalone is justified. After a judgment, there has to be also, I think, somewhere a sense of responsibility by the people who still propound an individual case that, look, this is now covered, that should go.
You forget PMLA, 120B used in every
Even
criminal
in every
offense
other
to
case
get
also.
to get involved, to get people as accused, who they want.
I really hope that judgments like this are also made in the other non-PMLA category and they are consistent. My fear is always that you make the right thing and then somebody changes the law in another judgment shortly.
Again, in 120B, there should be some legal parameters on the basis of which you can involve somebody in conspiracy. What are your thoughts on that?
No, my thoughts are on your last comment. See, one thing is to lament that the court is doing this, court is not doing it. That's one issue.
Yes.
I mean, there's no point of lamenting beyond a point. You have to bring a structural change in 120B.
Yes.
It's a 150-year-old law.
Correct.
It is being used or misused or whatever. Just as we were discussing that the power of arrest or custody should be with the body apart from the police, some structural change should be brought in that provision because it's a all encompassing provision.
Exactly.
120B, conspiracy, small conspiracy, big conspiracy, larger conspiracy,
Correct.
all these things are developed.
Exactly.
So you put in something in 120B, and if the legislature doesn't do it, the court should step in to say that the rigors of 120B will be tested on these
parameters.
कि भाई some prima facie material कि तुम उनसे मिले हुए थे.
Correct.
In some form or the other.
Correct.
And the classic test is a Privy Council test, where some people robbed a bank. One guy was waiting in the car, the getaway car. He argued that, look, I didn't do the robbery, I was only driving the car. So they said, no, you are a part of the scheme and you were looking कि police na aa jaye, and therefore you will be a part of conspiracy because you were in the scheme. So the cases you were talking about, this man doesn't know what is going on there.
Exactly.
So unless there is some structuring, it's said by Privy Council 100 years ago. So you structure that through the court. It won't happen through Parliament. Structure it through the court. Take out the Privy Council judgment. Put your own imprimatur in whichever manner you want into it.
Mukul, I have seen cases के किसी ने speech दी मुंबई में and some violence took place in Delhi. They will say, but he was the linchpin, the man who gave the speech in Mumbai, and he'll be involved in conspiracy. Well, I've seen this happening. And people are in jail for 3 years, 4 years for this kind of stuff. But this is a very serious issue.
बहुत बहुत महत्वपूर्ण बात जो ये कर रहे थे वो है 120B यानी कि क्रिमिनल कंस्पिरेसी। आप किस तरीके से किसी जुर्म की साजिश या षड्यंत्र में सम्मिलित हो, ये कानून इन तीनों के हिसाब से इसको और अच्छे तरीके से परिभाषित करना जरूरी, ये बताना जरूरी है कि किस तरीके से आप उस साजिश या उस षड्यंत्र के हिस्सा थे। और मुकुल रोहतगी का ये कहना है कि क्योंकि ये प्रावधान 150 साल पुराना है, यानी कि अंग्रेजों का, अब जाहिर सी बात है इसको चेंज किया जा रहा है, जो नए कानून आ रहे हैं, लेकिन वो भी एक अलग मसला है। उनका ये मानना है कि सरकारों से ये उम्मीद करना कि वो इसको पार्लियामेंट में एक बिल ला करके लाएं, वो तो मुमकिन नहीं है, कोई भी नहीं लाना चाहेगा, जाहिर सी बात है, क्योंकि इससे उनका काम आसान होता है। उनका ये मानना है, और लगातार इस चर्चा में जो बात समझ में आ रही है कि कोर्ट्स शुड स्टेप इन, कि अदालत ही उसको इस तरीके से परिभाषित करने पर जोर डाले, यानी कि घूम फिर के ये तीनों वकील ये अदालत से उम्मीद करते हैं कि वो कुछ इस तरीके का फैसला ले ताकि ये कानून सही मायने में परिभाषित हो सके। इनकी राजनीतिक मंशा या नियत कुछ भी हो, लेकिन कानूनी रूप से उनको कैसे पढ़ा जाए ये अदालत इसको तय करे। बेल के ऊपर, और हम फिर बात करते हैं, आइए बेल के ऊपर एक आखिरी चर्चा इन तीनों के बीच फिर हुई थी। क्या बोला इन्होंने, आइए आपको स्क्रीन पर अब दिखाते हैं, जिससे आपको एक आइडिया मिले।
This is a very serious issue. As a matter of course, no magistrate will grant bail. In the rare case, maybe.
I'll tell you, Kapil, you
This
would
is a
have
very
seen.
serious issue.
Our experience shows that when we started practice, the High Court used to write a 5-line order and grant bail. Hearing would last 5 to 10 minutes.
That's right.
As things progressed, these laws became more complicated. And unfortunately, the Supreme Court, which was supposed to be the beacon of these freedoms, despite saying bail is the rule, not jail, etc. The Supreme Court, I am sorry to say, has become small-minded. A large number of bail orders are today interfered with,
Yes.
which was never the job of the Supreme Court even 25 years ago.
That's correct.
Every second bail order is interfered with. A grant of bail is stayed by the court.
That's correct.
That you remain in jail.
Yeah.
Normally, if you have bail, it can never be stayed. You can
Absolutely.
cancel it in egregious
Absolutely.
cases, but you never stay.
Absolutely.
But since that is now happening in a mundane fashion, routine fashion, you know, that also filters down.
That's right.
I mean, High Court judges also say, if we grant bail, next day it is stayed, comments are made, why you granted bail? So it filters down, वहाँ bail नहीं मिलेगी, वहाँ cancel होगी तो हम भी नहीं देंगे. Remarks are made, अरे साहब सुप्रीम कोर्ट चले
The
जाइए.
mindset of the magistrate is कि भाई हम तो नहीं देंगे, आप हाई कोर्ट से ले आइए.
अब ये mindset हाई कोर्ट में भी है.
It's a very
और
strange
हाई कोर्ट कहता है
amalgam.
कि ये हम नहीं देंगे, आप सुप्रीम कोर्ट से ले
It's a
आइए.
ये
very
सारा
strange
ऊपर से
amalgam.
filter होता है.
It's a strange amalgam, Kapil. I think there is also a feeling being generated. अगर इसने बेल दी है तो सब कुछ दाल में काला है.
हाँ.
अलग अलग अपनी बात कह रहे हैं ये सारे वकील, और इनका ये कहना है कि एक इकोसिस्टम इस तरीके का बन गया है, या एक बातचीत इस तरीके की बन गई है कि बेल नहीं देना है, जबकि बेल जो है वो नॉर्म था, वो नियम था। तो ऐसा क्यों है जो चीज नियम थी वो अब नियम नहीं रह गई है? और आपने जैसे कि देखा कि वो किसी भी केस में किसी भी पार्टी को रिप्रेजेंट करते हों या किसी भी व्यक्ति विशेष को का प्रतिनिधित्व कोर्ट में करते हों, लेकिन यहाँ पर इन तीन वरिष्ठ वकीलों का ये मानना है कि पीएमएलए के जो प्रावधान हैं वो प्रावधान अभी जिस तरीके से लागू हो रहे हैं और जिस तरीके से कानूनी रूप से उनको अमली जामा पहनाया गया है वो सही नहीं है। और गुजारिश इनकी ये है कि अब अदालत इसको सही तरीके से पढ़े, एक 5 जज बेंच इसको पढ़े, ताकि फिर वो अपने आप में वो जजमेंट एक कानून बन जाए। जैसे कि इलेक्टोरल बॉन्ड पर, क्योंकि इतने सारे वकीलों ने बैठकर, इतने माफ कीजिएगा जजों ने सुप्रीम कोर्ट के बैठ करके ये जजमेंट सुना दिया, अब आप इसको चुनौती नहीं दे सकते, अब ये देश का कानून हो गया। तो क्या पीएमएलए पर भी इन तीनों वकीलों का ये मानना है कि 5 जज की सुप्रीम कोर्ट की संविधान पीठ बैठे और जजमेंट दे बेल के मुद्दे पर, क्रिमिनल कंस्पिरेसी के मुद्दे पर और तमाम मुद्दों पर? राजनीति से अलग हटके कानून की पाठशाला इस मुद्दे पर ये इन तीनों ने लगाई, और उसका एक, ताकि वो ढंग से समझ में आए। होता क्या है ना, कानून की बात है अक्सर लोगों के ऊपर से निकल जाती है, हमारे भी निकल रही थी, तो जितनी हमारा विवेक है उसको इस्तेमाल करते हुए, उनकी बात समझते हुए आप तक ये प्रदर्शन लेकर के आए। तो आज इस एपिसोड में इतना ही। ऐसे ही और कुछ मसले रहेंगे जिन पर बातचीत होती रहेगी, तो उसका भी हम एक सरलीकरण कर करके आप लोगों के सामने हिंदी भाषा में प्रस्तुत करते रहेंगे। तो द रेड माइक की कानून की पाठशाला में आज इतना ही। फिर मिलेंगे किसी और मुद्दे के साथ, तब तक के लिए नमस्कार।